My name is Liz. I'm with the Bozeman Public Library. And before I turn it over to Dr. Goetting, just a couple things about Zoom. So this is a Zoom webinar, so you do not have video or you don't have audio. I mean, you can hear us, but we can't hear you. So you can be noisy, you can talk, you can show up in your pajamas, and that's fine. The way that you can interact with us is there's a couple of options down at the bottom of the screen. There's a Q&A. If you submit a question, you can do it. You can submit it anonymously, and I'll be able to answer that way. Or if I respond to your question, it might go out to everybody, so everybody can see it. We'll try to get through all of the questions that you have as well. There's the hand raise option, which I see somebody did that real quick. And the hand raise will signal that, oh, you need more time writing a question, or you want to get our attention for some reason. And then every once in a while, we'll have a poll that will pop up. And those are pretty self-explanatory. Just answer the question on the poll. This webinar is being recorded, and these will be posted on YouTube and also on the calendar event page, so you can refer back to the old ones. And with that, I'm going to go ahead and turn it over to Dr. Goetting, who has kindly agreed to be here and do this for us, which is great. So thank you.
Okay, well, thanks a lot, Liz. And our topic for this evening is save more money for your heirs by avoiding probate. As I do programs across the state, one of the things that people tell me they're interested in is, how do I avoid probate? Well, sometimes they say it kind of makes a difference in what it is you're trying to avoid. But let me see that I can make sure that I can go down. Yikes. Okay, there I am. My latest photograph there, but I am a professor and Extension Family Economics Specialist at Montana State University. And my role is to take the university to the people. So I do live programs out across the state. For example, last night I was in Manhattan, and in January, I did something like 10 programs in 9 counties in 5 days. And after that, I knew I wasn't as young as I used to be. So I'm glad to have you join this evening and have the opportunity to sit here, visit with you, and you can write in the chat room, and Liz is going to let me know those questions. Now, you know, last week she was talking about being motivating and exciting and don't put people to sleep. And this week she's saying, be inspiring, be thrilling. Now, come on, is estate planning a topic that you would consider thrilling? Well, I'm going to try to make it that way, but I'll still try to keep you awake and not go to sleep. But to do that, those of you that attended last week know that I like to use engagement tools. And those engagement tools include the chat room. See my wonderful question mark here that was pine drops? Well, I want you to feel free to ask questions, and I'll see if I know the answer. And if I don't, I'll get back to you, I promise. And here's an example where you have a chance to let me know, did you attend last week's session? So Liz brought that up, and we'll get a chance to see how many of you are repeats, or, oh dear, did I turn some people off and they decided not to show up? Okay, so yay, 78% of you were here last week. That is good. We've got some newbies, so you may have some questions about some of the things that we talked about, but I think you'll find this part very helpful. So I'm going to close the poll and go on to the next question, and that is looking at another engagement tool, and that happens to be wildflowers. Now, you probably haven't attended too many sessions where somebody uses wildflowers, but I love to do that because what I find are the names can help you remember some of the key points that I like to make during the presentation. Now, for example, this is a steer's head, and can't you see that? You've got the ears, you've got the little eyes, and the nose. Great flower to talk about what I want to steer you to some answers to questions that we had last week that we didn't get around to doing. And Liz sent those to me in an email. And the other objectives that I have is to steer you to an awareness of how you could avoid the cost of probate with PODs. Those are payable on death designations on your financial accounts. I also want to steer you to an awareness of how you can use TODs, transfer on death registrations, for your stocks, bonds, and mutual funds. Now, those of you that out there have real property, guess what? You can even use a transfer on death deed and transfer real property, no matter how much value it has, to whoever you want to designate. And that doesn't go through probate. And then 2 years ago, we got the beneficiary designation for vehicles. So there's just lots of things that you can do now to avoid probate. Now, one of the questions that we had is, does a will supersede the word right of representation? And right of representation is a term that the state of Montana uses for how your property is going to be distributed if you don't have a will. Okay, and the answer to the question is yes. You are in control when you write your will, and you can leave your property however you want to. You can skip a generation. You can disinherit people. You are in the driver's seat when you have a will. And then there was a question about the widowed daughter-in-law. And we had an example of that, and I'll show you more about it pretty soon. But does she receive assets from the father and mother-in-laws? And the answer is no. So let me show you how that works. Here's an example that we had of grandma and grandpa. And in this case, grandma was the last one to pass away. Well, under right of representation, we see the division of the property is like this. We get one kid that receives a third. We have two pink children that receive nothing because their dad received it. And then we have the three green grandchildren that receive 1/9 each. So if you notice there, the wife that's in gray, that is the mother of the child that receives a third, it doesn't go to this daughter-in-law, which is the kid's mother. Okay, it's recognizing bloodlines. It always goes straight through down to the child. Now, we talked about whether or not that mom would be appointed as the conservator, and that's the one that handles the money for this child. And we agreed that she probably would be appointed by the judge unless there was really some extenuating circumstances. So this right of representation is a very important concept, and it's also one that some people have in their wills. And for whatever reason, they don't know what that means. So think of it this way. Grandma, when she died, had 3 children. Now, it's true, 2 predeceased her, but in this case, we have 1 that was living. So that's a child that receives a third. Think of this grandchild that's turquoise representing the dad because the child is the one to receive it. So we're going to look at some of this a little bit later as well, but that is just a quick review of last week. Now, this happens to be a mountain death canvas. I could tell you a story, and that story is I used this card in my early days of wildflowers, and I sent it to my best friend's mom who had cancer. Can you believe it? I was mortified, absolutely mortified that I'd done this. Well, luckily she knows me and says, Marsha, we lost 7 sheep in the Lima Mountains as a result of their eating mountain death canvas. So obviously that makes me think of death, and that makes me regard PODs, payable on death designations, that you can put on accounts at your financial institutions. And these would include your banks and your credit unions. So what we're looking at here are savings accounts, checking accounts, certificates of deposit, and even United States savings bonds. Now, the thing about United States savings bonds is they only allow you to have one. Whereas if you have 2 or 3 or 10, as one grandma wanted to do on her $10,000 CD, And of course, the bank was suggesting, why don't you have 10 CDs and name your child on each one of those? But that's for you to decide and visit with the financial institution. But the advantage of having a payable on death designation is that it passes directly to that person, and there is no probate of that account. Now, that's what makes it really cool. In the old days, what people used to do is put property in joint tenancy. Like one grandma, she had a $10,000 CD. And what she did was put it in joint tenancy with her grandson because she wanted him to have that upon her death. Well, he found out about it and he went in that booger and cashed in the CD. Now, that's not what grandma had in mind. But doggone it, I told her, I said, now you know what to do with the rest of your estate. And I had a feeling there's a grandchild not going to receive anything, and rightly so for what he did. Now, the other thing about a POD is that you can give that to your favorite nonprofit. And you could even say, for example, to the Montana 4-H Foundation for use in Gallatin County only. So, wow. It's really neat the legislature passed this particular provision, POD, payable on death designation. So you can use these to control the distribution of your checking, savings, certificates of deposit, and you avoid probate at death. So that's a POD. Now, let's look at a different situation where we have what I'm calling an heart-leaved arnica. Well, I'm calling it that because that actually is the name. And this is from the Deer Lodge National Forest. And we've got heart-to-heart estate planning that Joe Hart and Brooke Hart are doing. Now, Joe has really heartfelt intentions because what he wants to do is name his sweetheart and wife as the beneficiary of his certificate of deposit. Okay. And later, though, however, he changes his mind and he says, I bequest my $100,000 CD to my son, Eric Hart. Well, now we have another poll question coming up here because we want to know who is going to receive that 100 grand. Is it going to be Brooke or is it going to be Eric? Brooke is the designated beneficiary. We have Eric in the will that was written the most recently. So let me know with your clicker with the poll of who you think is going to receive that.
All right. And while people are answering that, we did have one question pop up. Is there an advantage to a POD if you have a will?
Okay. What I'll do is answer that because if you have a will, that is perfectly fine. That's what we do. But you see, the will has to go through probate and then the account has to go through probate. And in the old days, probate was calculated on a percentage of the value of the estate that goes through probate. No longer is that true. What they say is the probate fee must be reasonable. I'll let you determine what that means. But typically we're thinking about maybe an hourly fee for the attorney that is making sure this account gets transferred from mom's name to somebody else's name. So it's just the POD will avoid probate. A will not avoid probate. So in this particular instance, we can see here that we've got Brooke, 78% of you are saying that, and we've got 22% that said Eric is going to receive that. Well, the majority of you had that one right. Didn't fool you at all, did I? Because yes, Brooke, his sweetheart, is the one that's going to receive the POD. Think of it this way. The POD is a contract. Okay, you filled out that form and you can't undo a contract with a will. So you want to make sure if you've got a will and you've got payable on death designations, coordinate those, make sure they're the same. Don't have one going one way and one going the other way, because all you're doing is setting up family members that are going to end up fighting with one another, even though the law is clear, is the contract wins out. So if Joe wants to change that, instead of writing a will, what he needs to do is go to his bank or credit union and fill out a new POD and give that amount then to his son, but he only gets it after Joe has died. Well, you guys did so good. So therefore, you are not going to have to say this out loud like some of the people at my meetings have to do. And I bet some of you out there have a couple of gray hairs like me, and you can remember the days when Mitch Miller was there. I think it was Mitch Miller, and he had this really cute ball where you'd go along and say, oh, you can't undo a POD with a will. Now you know why I was not in course in high school. Okay, moving along. So have a heart. Make sure that you review your PODs once you get them and set up some system for finding them. I used to have mine at the back of my bank thing, and then I had another one, and I go, it's too difficult to find it in all that paperwork. So finally, I just did folders for my CD at the bank, one at the credit union, and that type of thing. So that's looking at the POD situation. Now here I have an albino fairy slipper on the left. See, it's white, hence its name. And when I first saw it, I thought, oh, the poor thing is sick, because you can see on the right, that's what it's supposed to look like. But I couldn't help but be thrilled that I was seeing my very first albino fairy slipper, and I'd never seen one before. So for me, it was very exciting. So I thought, I got to figure out a way to use that in my presentation, of course. So we're going to look at the albino family. And we're looking at the albino family that has, haven't you seen this before? Mom and dad, 3 kids, and grandchildren. Okay. Now, this mom has a certificate of deposit. Okay, it's a 100 grand. And we want to know then, is it going to go to the children by right of representation, equally to the descendants by state law, or heirs at law? And I bring this up because when you're signing your POD, you've got to look at that teeny tiny little print that's there with the financial institution and see how they're going to divide it if you didn't put in a successor beneficiary. You may want to name one kid as your primary, and then maybe that kid's kid, like a grandson, as secondary. You can do that at the financial institution. So when we look at this example and we find it's by right of representation or heirs at law, well, what fraction is that kid going to receive? We'll see how good you remember the first slide I showed. Okay, so tell me with your clicker, what is the fraction under right of representation? Okay, we're running 100% correct so far. And the rest of you are afraid to do it because you don't want to look like, oh, I didn't know it. I'm afraid I'm going to miss it. Okay, we're going to close that out because, yeah, I really did give it away. It is indeed 1/9. Okay, so same example there, but it lets you see how that right of representation appears not only in maybe a will, state law, or some of these contracts we're doing. So if you know the meaning of right of representation, you are way ahead of the rest of your friends. Now, let's say that mom's POD is equally to her living children. Okay, so, well, no, she just says equally to my children. Okay, what does that mean then? Well, her children is the one son that's still living. The other two aren't, and therefore those grandkids did not inherit. So what I'm saying is it's very important for you to read the small print, understand what that means, so you're accomplishing your financial goal or your estate planning goal in that case. So Montanans really do need to understand this right of representation business and understand that when you use it in a will or it's in a form, you know exactly what that means. Now here we have another death canvas. When I first started studying these, I thought, how am I ever going to tell the difference? Well, of course, once you see them for a while, you start figuring that out. But what that makes me think about is the transfer on death registration. Now, some of you have already done this, and it was called a beneficiary designation at the time you did it. That's fine, not a problem. It's just now it's a TOD registration because that's what the legislature said in the provision where they were offering this. So again, stocks, bonds, and mutual funds. And what happens then is these TODs pass directly to the individuals that you list, and then it's their decision. Gee, now I've got all this stock. How cool. Well, yeah, it is theirs. And see, it's their decision. Do I sell it or do I keep it? It's totally up to them once they become owner of their share of that stock. Now, the other thing about a TOD is you can also use it for your favorite charity or nonprofit. You know, we've got the Montana Community Foundation, and we have the One Valley Community Foundation here in the Gallatin Valley, which is really, really neat. And they're doing lots of good things. So you can use a TOD to control who you want to receive interest in your stocks, bonds, and mutual funds. Up to you to make that decision. Now that you know about TODs and PODs, is that something that you would place on your accounts, or do you already have them and you're way ahead of the game? So let me know by clicking on your answer.
All right, I have a quick question about TODs. Can they be applied to an IRA that is managed by a financial service?
Yes, and I will dare say that when you established your IRA, you did name a beneficiary at that time. Mm-hmm. Now, it's just something that was done then, but now we have the Secure Act that was passed at the end of December, and that's going to have a big impact on people's traditional IRAs. And here's the reason. You see, when you have a traditional IRA, any money that comes out to you is taxable. You have to put it on top of your income. Well, the same thing happens when you leave that IRA to, say, your kids or your grandkids. Well, some people out there were kind of smart and they're saying, you know, what I could do is TOD these to my grandchildren. And then the grandchildren would get to draw it out based on their life expectancy. So here's an amount in there. And let's say they're 20 years old and they have a life expectancy of 40. Well, they would be able to take out 1/40th. And then the next year, kind of 1/39th, you know, you can see what's happening. The amount that you're taking out is so small, the tax impact is not as big. Well, with this Secure Act they passed, and we're still taking a closer look at it, what they're doing is saying, oh, no, you can't do that anymore. There's people that have to take out the amounts in 10 years. Now, a spouse doesn't have to do that, but there's some others that you might name. So the attorneys and the accountants are getting in contact with their clients and just saying, hey, if you have any nonprofit goals, charitable goals, give the IRA to the charity because it doesn't become taxable income, and leave other assets to your kids and grandkids. So if you get a call from your attorney, asking you to look at your plan or whatever is going on. Don't think, oh, he's just out there trying to make money. It's, hey, this is the time for you to make some decisions because it might influence what you're doing. Okay, I need to move on here with our poll, and we're seeing that 63% says that they are going to open a TOD or a POD. Well, I say open, place the designation on the form. And then 38% of you already have them. So that's very good for you guys. Very good. Now I have an explorer's gentian. And these are beautiful flowers that you can find in a forest long about August. And what we've got is a transfer on death deed. Now, some of you may have already filed a beneficiary deed. That's the old name. And 2 years ago, they came up with this transfer on death deed. How is it different? Can't tell you that, but it's the new one. So that's what we're going to do. And what you can do is look at real property. That's your home and anything that's attached to it. And you can transfer like $6 million of land without probate. I did not think I'd live to see the day that we could do something like that. So it's very interesting, but don't get real excited yet because I've got some things to tell you. Okay, when did this become effective? In 2019. Okay, beneficiary deeds were prior. And the thing is, the beneficiary is not the owner until you die. They can't use your home as a collateral for a loan. They can't sell your home out from under you. It's not theirs until you die. So how do you do this? Well, you have a transfer on death deed form and you file it in the clerk and recorder's office where the property is located. So I'm going to assume most of you are in Gallatin County. So you're going to go down to the Gallatin County Courthouse and file your TODD there. Okay. Now let's say that you own property in more than one county. That means that you have to file your TOD in two. Maybe you've got Gallatin County and maybe you own some of that oil land out there in Richland County. Ooh, wouldn't that be neat? Anyway, you've got to file that in both, in each county. Okay. Now, who can be your designated beneficiaries? That's what they call them, designated. Spouse, children, relatives, friends, even a corporation can be named. And ta-da, your nonprofits. So you might have the Montana Community Foundation. And of course, I think you should support the Bozeman Public Library Foundation. And they didn't pay me at all to say that. I did it on my own because I really love the library. So we have, through your taxpayer dollars at work, a Mont guide. These are fancy term for a fact sheet. And I put a lot of information in there. My co-author was one of the people that said, I testified against the bill. Yeah, my mouth dropped like that when she told me that. But she said there's real concerns there that people are going to jump into this and they're not going to think things through. So my one-page fact sheet turned into 8 by the time I got some of those kinds of things in there. So don't jump into doing a transfer on death deed till you become better informed. So we're going to continue to explore whether or not a transfer on death deed is best for your situation. Now here we have a foxglove, and I found this one in Glacier National Park. And I thought, well, that's really a pretty one, but it made me think, aha, let's say that we have a designated beneficiary up and die before we do. You know, that wasn't the plan. So you got to outfox the law and just be a little foxy, because you need to specify, first of all, a successor beneficiary. You've got yourself in there, but you need a beneficiary. Okay. And now I'm getting to the part, what if that person dies before you do? So here we've got Mark. And Mark is saying, if something happens to me, I want this land to go to my son, Evan. But if Evan dies before I do, and I don't get around to doing a new beneficiary or transfer on death deed, I want it to go to Luke, my grandson. And you're not limited to just one. You know, you can have 2 or 3, whatever fits with your family situation. And of course, you could always name a nonprofit as your successor as well. So that's something to think about. Not only do you need to decide, is this something for me, but if it is, who do I want to be the successor beneficiary? So outfox the law by naming a nonprofit or someone else as your designated beneficiary. Now here we have a blue flax. And I'm sure you've seen these along the side of the highway. Usually they're flying like this. And I don't know if you've ever tried to take a picture of one. Oh, super challenging because it's tall. And even though you think the wind is not blowing, you get there with your camera, you magnify it, and it's just shuddering. And it's difficult to get a photo. So I'm so proud of this one that it's not blurry. So that reminds me of Gary Blue and his 2 blue children. So we got Gary, we've got Linda, and we've got Matt. So Gary has decided that he is going to file a transfer on death deed, and he is going to name Linda as his designated beneficiary. So that's what he does. He goes down to the Gallatin County Clerk and Recorder's office and he files it. Well, sometime later, what Gary does is he writes a will, and now he's leaving that same property to Matt. So you know what's going to happen, don't you? Gary's going to die, and who gets the property? Is it going to be Linda Blue or is it going to be Matt Blue? Tell me by clicking on Linda or Matt.
Seems everybody's in agreement.
You know, that is good. I commend you guys because I asked these questions just trying to see how good a teacher am I, or else you're just extra smart, of course, but everybody got this one right. And so this is normally where I would do a dance if this was live, because it seems like, well, I just tell people, if you missed it, it's not your fault. It's my fault. Okay, but you've got it because you see that transfer on death deed, right? It's a contract, isn't it? And you have to undo that contract by revoking your transfer on death deed, which you can do, or you file a new beneficiary deed. So let's see what happens here. Yep, Linda's got it. Poor old Matt, he gets 0. And of course, he's saying, Linda, obviously dad wanted me to have it. He wrote a will. And oh dear, what do you think Christmas and Thanksgiving is going to be like in that family? Not good, I have a feeling. So we've got Matt singing the blues because he didn't get the property. Now, it could have been that Gary Blue would leave it to the Montana 4-H Foundation for use in Gallatin County. Could have happened. And then both Matt and Linda are singing the blues. Now, here's the caveat. Man, when this property or this new law was passed, we were all excited. At least I was, because I didn't think it ever happened. But here's the deal. Some title insurance companies are not providing title insurance for at least a year. And I understand their viewpoint because they're saying, look, we don't know if some creditors are going to come in and, you know, we can't issue title insurance if we don't know if there's a lien on it or blah, blah, blah. Well, it's disappointing. So here's what you might want to think about is if you're leaving this with a Todd and they want to sell it immediately, let's forget about the transfer on death deed. Let's think about going ahead, writing a will. and then you leave it, and your personal representative then will jump right in there and start the process of the probate. The creditors will be notified, and they have 90 days to send in their bills. And it could be that this would happen a lot quicker than the year time. So it's something for you to think about. If it's going to a kid that's going to keep it, and can do without that title insurance for a year, hey, you could still do the TOD. But certainly something to visit with an attorney about in your specific situation. And just a reminder, probate fees are reasonable. No longer, don't let somebody tell you that it is based on a percentage of the value of the estate. No longer is that true. So you can't undo a transfer on death deed, regardless of if the will was before the deed was filed or after the transfer on death deed was filed. And we have a mock guide on this, like I said, the 8 pages, and you be sure and read that so that you can make an informed decision about whether or not this is something for you. Now, here we have the fringed grass of Parnassus. Now, I really tried to come up with the justification of using this flower, like words that rhyme or something. But I just got to tell you, the name was intriguing. The photograph I thought was good. And it's not one that you can get usually until August. And it's usually near running water. So my fringed grass of Parnassus is looking at a new Montana law that occurred 2 years ago. And that is a beneficiary designation for a vehicle or vessel. Okay, it became effective October 1st of 2021. And the form that they're using for that is MV13. So that is available at the Motor Vehicles Division of the Department of Justice. Now, let's take a look and see what we're talking about when we say a vehicle or a vessel. And the vehicles are the car, it's a truck, any kind of thing like that that needs to have a title. And then what we've got are some of the other vessels that I tend to think of is their water things, like a sailboat, motorized boat, personal watercraft, any of these that have a title. Okay. But right now they're saying airplane isn't, a manufactured home isn't, and a mobile home isn't a vehicle or vessel. And then I put the green in there about the 2023 legislature. There has been a statute introduced to make a manufactured home a vehicle. And it may pass, it may not, but they're really looking at that one and saying that would be a good thing to do. So we shall see. Stay tuned. And of course, I had a mock guide done, and it looks like I'm going to get to redo it before it even gets published because it's been a while. Now, how do we go about designating a beneficiary on our vehicle? Well, when you buy a vehicle, it could be a new one, it could be a used one, and you're applying for a Montana title, you file the MV13 with that paperwork. Okay, so there's always a fee involved. You got to pay for the title and then etc. But that's when you can do that. Then you may be in a situation where you want to add a new beneficiary to the beneficiary that you have on record. Okay, so you file for one, and then later you decide, oh gee, I might as well add Susie to it too. So you've got 2 people there. But the Motor Vehicle Division will only allow you 2. You can't have more than that, just 2. So that's our second way that we can have beneficiary designation on our vehicle. The third thing we can do is we're going to change the beneficiary. Maybe we had John on there and John passed away. And so we want to name somebody else to receive that vehicle. So you can do that with filing, again, that MV13. Now, the fourth way is technically not adding anybody. It's simply saying, I hereby revoke all my current beneficiaries. Okay. What we want to make sure that we do is fill it out. Well, in this case, what they say is include the form and put it with the rest of the paperwork. And of course, I'd be tempted to put on that right now because it's still a form that's in flux after if they make another change, is to say, I hereby revoke. Just to make it perfectly clear when it's in there, I'm revoking my beneficiary designations. Well, what else could you do with your beneficiary designation? Of course, you could do a nonprofit. And here in Gallatin County, we certainly don't lack for nonprofits in our community. We've got Warriors and Quiet Waters. We've got Family Promise, Eagle Mount, Haven, Thrive. These are all very worthwhile nonprofits. And, you know, if you just don't think anybody would really appreciate that vehicle like you do, well, we could leave it to a nonprofit. And of course, the nonprofit will probably sell it. And at least that would be a way that we could make a donation after we're gone. So the tip from the fringed grass of Parnassus is to take advantage of this new law that we have in Montana, where you can designate a beneficiary on this form MV13 for a vehicle or vessel. Anything that has to be titled in that area. So sometimes it could be a trailer that you're pulling that you put stuff on. Whatever it is that needs a title, you can use this new law for. Okay.
So real quick before we move on, so mobile manufactured homes, could they be covered under the transfer of death deed for like property, for like land?
Well, good question there. And that's what we thought we could do originally. But they were saying no. And so that's part of what they're trying to sort out because, you know, a mobile home is going on the road sometimes and you may move it the same way with a manufactured home. We split it out and it goes down the road two ways too. So that's part of the argument of why it should be considered as a vehicle. And sometimes what happens is the legislature passes a law, and then the details of that law weren't necessarily in the original law. What they do is they turn it over to like the motor vehicle department and say what you need to do is develop a form and blah, blah, blah. So that's what was done. And it's just that division ruled that it is not. The trailer and the manufactured homes are not. So like I said, we'll see what happens by the end of April when everything has been handled. So we're getting to the end here. I've gone faster than I thought I would. And what I've got is an observation from the fairy slipper, or lady slipper in this case. This is a lady slipper, not a fairy slipper. And this one, I have to confess, my husband and I like to take photos. And then what we do is we put them on the computer and then we both look and vote on which one was the best. Well, there was no question. Gary's was the best in this case. Mine wasn't as nice, but isn't that beauty? It was one of my first fairy slippers that I had seen in the state. So I was very, very excited about it. So full credit to Gary. So I hope I did steer you to an awareness of how you could use payable on death designations on your checking, savings, certificates of deposit, and even your United States savings bond. But remember, savings bond, one person, no more than that, and that's a federal law. I hope I steered you to an awareness of how you can do a transfer on death, and they call it a registration. Now, I've had a couple of people at my meetings that say, now, wait a minute, you talk POD, you talk TOD, which one is the best? And you see, it's not a matter of best. It's the legislature said a POD is on checking, savings, certificates of deposit, and a TOD is on stocks, bonds, and mutual funds. That's the difference. It's not one is better than the other. It's just that's what they did. The other thing is, I hope I steered you to an awareness of the transfer on death deed being available out there, but also with the caveat that we have this issue with title insurance. And I hope I steered you towards the beneficiary designation on your vehicle or vessel and how you could avoid probate. So my goodness, Montana is now set up where there's almost any asset that you've got that has some sort of name attached to it that you can use a beneficiary designation of some type on that. Now, you might say, well, I don't need a will. And I would disagree. What the attorneys say is there's always something that somebody forgets. You know, they had a savings account back when, a CD, there's something they forget. And so you still need the will. And my reason for thinking that you still need the will is in your will, there is a paragraph that says, I have a separate listing of tangible personal property. Well, what the heck is that? Those are things in your family that have emotional value. We could say they're heirlooms, or maybe they're not. Maybe they're a rocking chair. And this one grandchild remembers grandma rocking him in that chair. And oh, would he love to have that? So it's not something that would sell for a lot of money. It's just something that has emotional value. So families, you know, we've got guns out there. We've got jewelry, books, coin collections, stamp collections, those kinds of things. You have the paragraph in the will. The paragraph gives legal authority to the personal representative to take that list and say, okay, Susie, this is what you get. Johnny, this is yours, which is much better than letting all the kids come on in and have a free-for-all and having people mad at one another. You know, I always tell people, let them be mad at you. You're gone, but they're going to honor your wishes. And that's the good thing, I think, in having a will with this separate listing. And any of you that have a trust, they passed a provision in several years ago for doing a very similar thing to a trust. Because you see, your trust has things that are titled, and you have to retitle it in the name of the trust. Well, how do you do that with grandma's rocking chair? Well, you have that trust document that says to the equivalent, I have a separate listing. And then you have that separate piece of paper that the trustee then will use to distribute those items to the individuals that you want to have those. Now, I bet some of you are out there and maybe you don't have a memory like an elephant's head. And that's what my grandma always said. Elephants have a long memory. And I hope you've had a chance to see this particular flower out in the woods. See the ears? They're just out there and the trunk is there. Ah, they're so cute. We've got now 50 different mock guides in the estate planning area. And most of those are specific to Montana. Anything that's kind of federal type that's out there, like individual retirement accounts, it's not any different in Montana than someplace else. But I've tried to focus on Montana laws. And I really think I've done a lot of that. And then don't forget, we have these also available at the Gallatin County Extension Office. And that's out there at the fairgrounds. So if you happen to be out that way, you want to stop in and pick up some of those mock guides, I'm sure they'll be glad to do that for you there. And then I wanted to sort of advertise our Fabulous Fridays programs at 10 o'clock on Friday are now over. But we do have all the recordings from the past, as well as resources for each topic. So I've got one in there on trusts. I've got one in there on what happens when you sell your property after you inherit it. What are there capital gain issues? Some things like that, of items that people have had questions about. And during COVID, I wasn't traveling. So I finally had a chance to get some of those kinds of Mont guides done. One of them is selecting an attorney to handle your estate planning or a probate. Lots of Mont guides specific to Montana. So next week, I hope you'll tune in again. And what we're going to do is look at a revocable trust, which is typically called a living trust. And we're also going to look at testamentary trusts. And testamentary trusts are those trusts that you form after you're gone. So that's the difference between the two. Living, you do it while you're alive, you manage it while you're alive. When you die, you write it in the will that you want to have this trust with some of the details, and we'll have more information about that next week. So Liz, are there some questions there that I should be looking at or answering, I guess? Whoops.
Yeah, so we actually had a follow-up on the mobile and manufactured homes question. And one of those was, can mobile manufactured homes be willed as personal property then?
But there's a title to it. And so I wouldn't, I'm not an attorney, so I can't give legal advice. I would say contact your attorney. But one of the reasons I wouldn't want to do that is because I know a manufactured home does have a title. And so we want to mention that in the will, but not as a separate listing of tangible personal property, because it really doesn't qualify under those rules. It's these things that don't have a title that are tangible. The others, you know, legal terms, intangible. So I'd be careful about that. Okay, Liz, I'm not on the screen. They can see some other stuff, right? Shall I bring my...
Yeah, so right now we're showing your Word document.
Okay, you probably don't want to see about Alzheimer's, so I'll bring that one back.
You can also just end the share screening too as well.
Oh, how about this? Does
yeah,
that work?
that works.
Bye.
All right.
Someday I'll learn all of this and how to do it right. Okay, any other questions out there?
So one person says that their financial advisor says that beneficiaries need to have their social security number on whatever it is that that gives them that money, that item.
We don't put our social security numbers on anything that is a matter of public record. And you see, when you file a beneficiary deed, it is indeed a matter of public record. So I would say don't do that. No, it's not required in the transfer on death deed at all. And that's the other thing that we have with our transfer on death deed is we did put a couple of forms out there because the legislature had suggested items to include. Mm-hmm. And when they do that, MSU Extension can make a form available. But just to practice law and come up with our own form, no, we wouldn't be able to do that. So I'd be very cautious about using my social security number that way. Okay. There's been too much fraud out there on our seniors and other people.
Okay. And then somebody asked if you can point them to the logistics on the session in Columbus in April that you mentioned.
Oh, yes. I tell you what, my suggestion would be is you go to the Montana legal, use your favorite, well, I'll just say Google or whatever, and do Montana legal developer. And it will come up. And then there's a place where they have a list of all the places that they're going to be. And Columbus is one that's close to us, but what date it is in April right now, I can't remember. And if you can't find it, I'm in the office tomorrow, or not in the office. I am on my computer. Just email me, Marsha.Goetting at Montana EDU. And I'll send that to you because I had a couple of people from last night wanting that information as well. And so I've got an email ready to go with that information in there. And it's a great program that Katie Lovell and her crew are doing, because you fill out some stuff ahead of time. Then they have pro bono attorneys that are there to look over the wills that they come up with you. Now, for you must be 60 or older, though. I should mention that, for them to be able to do that, because they're on a special federal grant that allows them to do for seniors. And hey, that's great.
Okay.
Okay.
All right. So I don't have any more questions at the moment. Feel free to raise your hand if you're working on typing a question.
Yeah, we don't want to cut anybody off.
Nope, we don't. I will have this video posted on the event calendar page and on YouTube, so you can refer back to it. I've also included my email at the bottom of that page. So if you have any questions regarding access or issues with Zoom or whatnot, you can reach out to me. And I'm not seeing any indications that anybody else has any questions. So I think we're good to call it a night. And I just want to say that I absolutely love your wildflower pictures. They are great.
Thanks a lot. You know, it's a great hobby for the summer in Montana. And the only thing about all this ice and snow, it's going to be a good wildflower year.
I have to dig out my camera then.
Okay, yeah. Well, thanks everybody for tuning in, and I look forward to seeing you again next week. And in the meantime, be safe and keep healthy. Okay.
All right. Thank you. Have a good night.
Bye-bye.
Bye.